Welcome to Bankruptcy, Through the Looking Glass, with Barry Levine.
Hello and welcome to Bankruptcy Through the Looking Glass with experienced attorney Barry Levine. My name is Kevin Rosenquist. I'm your host today, and we're going to be talking about how to get a financial fresh start with bankruptcy versus the mess of debt settlement. Barry, always good to see you.
A pleasure. The short answer, marry somebody who's rich.
You know what? That's the best advice I've heard all day.
Well, I say I didn't do a Dun and Bradstreet on my in-laws, and my father was a teacher, principal in the New York City school system. So what can I tell you?
What can I tell you? Yeah. How does the debt discharge process work in bankruptcy versus debt settlement?
It's a definitive thing. I mean, when you file a bankruptcy, debts are listed in categories. There's secured debt, which would be a mortgage on a house or a loan on a car. There's priority tax claims, which would be money due the IRS, money due in Massachusetts, the Department of Revenue, or any other taxing authority. And then there would be your unsecured creditors, the credit cards, the loan from a friend, you name it, any kind of debt. Basically, all of those debts, except the tax claims for the most part. And then the tax claims, I want to bog people down in bullshit here, but, tax claims should be distinguished between taxes that are due for not paying income tax, which under certain circumstances can be dischargeable. And we can oftentimes determine that going in, or what are called trust fund taxes. Trust fund taxes are taxes if you had a small business and had employees and withheld from the employees but didn't pay the government the withholding, that's a trust fund tax. If you run a restaurant and collects meals tax and don't pay the meals tax, I mean, I may have said this before, businesses that are having difficulties, that sort of cash flow is very easy to tap into because nobody's standing there with a gun making sure you pay it to the IRS or the state taxing authority, and trust fund taxes. And the same would work with sales tax. And the thing is, those taxes are non-dischargeable and generally have to be dealt with in another process, an offering to compromise that you do with the IRS, which is a story for another day. The creditors, I mean, even, and again, I'm sorry if I'm bogging you all down with legal bullshit, but even the mortgages get discharged in a bankruptcy if you do nothing. Not the right of the mortgage company to enforce their mortgage against the real estate, but what gets discharged is the hypothetical, and I don't know if anybody knows what happens when a foreclosure takes place. Well, let me give you a little example. If you don't make the mortgage payments, the bank will eventually foreclose. I mean, it could take a while. In Massachusetts, it can take a year and a half. In the meantime, you're not making payments. Life is grand. And when they foreclose, so let's say your house is worth $600,000 and you owe $500,000 on it. Well, I can give a better example. Your house is worth $600,000 and you owe $800,000. So now they foreclose on the house. Generally, the rule of thumb is it brings in 60% of its value at the foreclosure sale. Can you do the math? What's that? 500, 600, 60%? 360,000. Yeah, I got a 99 in the New York State Regents exam. So
I did not.
You see where it got me. And so now you're liable for the deficiency. And the deficiency is the difference between what the house brings in and what you owe. In this case, it would be $440,000. When you go through a bankruptcy and you get your discharge, and I'm suggesting letting the house go to foreclosure or anything like that, but just as an example, you discharge that hypothetical deficiency. So in this situation, if this person, and I've had people do that too, in this situation, you have someone, the house is underwater, they get their discharge, and somewhere along the line, they say, hey, shit, I'm looking to make money on the house. It's still underwater. They could then walk away from the house without any consequence because the deficiency would have been discharged as a result of their bankruptcy discharge.
Okay.
Now, of course, banks don't like to have that happen. And actually, debtors, to a certain extent, don't like to have that happen because from a debtor's point of view, it's called the reaffirmation of a debt, which is why what that means is you're agreeing the debt is going to survive your discharge. So in the case of a mortgage, we indicate when we file the case, there's one of the documents we file that the debtor intends to retain the house and reaffirm the mortgage. The bank then sends us the reaffirmation agreement. I fill it out, send it back to the bank. It's income and expenses. They send it to the court, and the court has to determine that it doesn't impose an undue hardship on you.
Okay.
I can't tell you before I look at the numbers, but generally, if there's equity and the debtor is employed, fine. In the other case, let's say if there's no equity, the debtor is making no money, the court may not allow it, in which case it gets back to it's called pay and retain. You keep making the payments because they don't want the house. But see, one of the reasons I keep Kafka on my desk is that if you don't reaffirm the mortgage, on your credit report, it shows up that the mortgage was discharged.
Okay.
Even if you've made 10 years worth of payments after your mortgage discharge. Now, not to toot my own horn, I was friendly with a local rep here, and I had actually drafted a statute that would force them to report that the payments. Because what happened,
That's only fair.
How I discovered it is a client came to me. He was in one of those underwater situations. It had been the aughts when the computer business was going crazy. He managed, the house was underwater. His business went out. He managed to keep the house. And it must have been 8 or 10 years later, he comes to me and says, "You're not going to believe it." I said, "What?" He went to apply to refinance his mortgage with his bank. And his bank had received 10 years worth of payments, said the mortgage had been discharged in bankruptcy. There's nothing we can do about it.
Same bank that he's been making all those payments to.
They received 10 years worth of payments.
Yeah.
And so it prompted me. I got in touch with the rep, and I basically making them disclose it. I mean, sure, it was discharged, esoterically, however you want to, but at least a creditor from a credit report, looking for a new mortgage, instead of getting into an explanation of, here are all my checks for 10 years. I know it says, they made all these payments. And unfortunately, the legislature in Massachusetts has better things to do than work on my statute.
You know what? Just hold on, Barry. Someday you'll get there.
Well, they'll erect the statute.
How long does bankruptcy take? Like the process itself, typically?
The process, I mean, the length of the process is really determined by the client. Because as we learned early on, I cannot be a creditor of my own debtor. So my fee needs to be paid along with the filing fees. And, we pull a credit report, and if they own a house, we get an appraisal. That all needs to be paid before we file. Now, in a perfect world, when I quote them my fee, they'd say, "Barry, who do I make the check out to? Is it Levine? Is that how you spell it?" But, as you can tell, I'm a cynic, and I'm also from Brooklyn. There's no such thing as a perfect world. So to retain us, and this is the typical case, they pay us $250. We bill them the balance. We don't charge interest. We don't charge penalties. My assistant, Kathy, has it set up. I've actually learned to do it because she was out, had surgery. They can set it up to pay it online,
Hey, look at you.
State of the art, right?
Yeah.
And we just ask that they pay it off within 6 months.
Okay.
But once we've been retained, and then if the creditors are nudging them, if the creditors are sending them letters, they refer them to me. And I start, for lack of a better word, jerking them around. I mean, because I tell them I've been retained to file a bankruptcy. And the one thing, in Massachusetts, most of the collection agencies and most of the collection firms know me. And when I say I've been filing a bankruptcy, there are lots of guys who over the years would use it as a bullshit tactic. It's the emis. When I say it, it's going to happen.
It's going to happen. Yeah. You're not. You're not blowing smoke.
Yeah, and generally I deal with them. That the retainer that doesn't cover and I usually explain to them the collection process, which is a lengthy, is as long as you don't ignore things, because nothing happens overnight. If somebody I have people come in here, there's a foreclosure today at 1 o'clock, and it's like 9 o'clock in the morning. That doesn't happen. The bank just doesn't wake up and says, I'm foreclosing today.
Yeah.
So when it comes to litigation, having me defend lawsuits pending the bankruptcy is a waste of time. It would cost them more money than what I'm going to charge them for bankruptcy. But what I tend to do, I always do, is I have a nice schmaltzy letter I send the creditor's attorney. Like I said, most of them know me, and I tell them that I've been retained to file a bankruptcy, and my client has neither the financial wherewithal or the inclination to defend a lawsuit on a claim that she's going to discharge in a bankruptcy. And basically, if they want to keep wasting time, it's like, have a nice day. I'm not going to dissuade them from doing it. But from my client's point of view, as long as they tell me what's going on, in Massachusetts, do you know how the collection process works? Why would you?
Why would I?
So
I don't know how the collection process works where I live.
Well, it's probably, you get served with a complaint, right? And again, getting back to a perfect world, you'll write the creditor a check, but that's not going to happen. So the debtor can file an answer. And then what happens now, especially with all the collection firms, and when they file complaints, you get a copy of every statement from the credit card, you get a this, you get a that, and immediately they send you discovery, which is interrogatories. You know what that is? Questions, a request for production of documents, and a request for admissions. And when you're dealing with a credit card debt, you got any defense?
Not really.
And eventually they'll get a judgment. And again, this is in Massachusetts, they'll get a judgment against you. And that judgment can be a year down the road, 6 months down the road. It takes a while.
Right.
What I become concerned with is that in Massachusetts, after a judgment, they have what's called supplementary process. It's like debtor's court. I think it happens every Thursday in the district courts. Been a long time. What happens is they issue a summons for you to appear in whatever district court has jurisdiction over wherever you're living. And if you show up, and what we tell them, and now most of the stuff is on Zoom, is if you show up, just tell either the attorney who's there, who's not necessarily the attorney who's handling the claim, but just some guy who's covering the hearing, just tell them you've retained an attorney to file a bankruptcy, and you should be out of there fairly quickly. And if you have to go to the judge, tell the judge the same thing. Give them my name, my information. I don't give a shit. And the judge will usually say, come back in 6 months. The problem arises when, debtors like to be ostriches and stick their head in the sand and ignore things, is when the debtor ignores that summons. What then happens is the judge can issue a capias for the debtor's arrest. And now the debtor is, going up 93, looking at the foliage in New Hampshire. It looks great, gold, this, that, and the other thing. And there's a trooper pulls him over for speeding and says, wants and warrants from the Newbury District Court. And the next thing they know is their ass is being hauled into the local state police barracks because there's a warrant for their arrest.
Wow.
And again, it's easy to deal with. I'm not the one being arrested, but, you can deal with it. But the best way is to not let it happen.
Right.
You show up at that hearing, that's not going to happen.
Right.
And very often, I get it across to most of my clients, but when I was a young attorney working he was known as the business doctor, I won't mention his name, the clients were getting left and right. They would not, they would ignore these hearings and, you give them a reason to pull you in.
Yeah. It never really works to kick the can down the road. It eventually catches up.
So that's the only, if the litigation is going on. So then eventually, before you can file a bankruptcy, you have to take a credit counseling course. I used to say, but I don't care what I say. I used to say it was for idiots, but I decided that that's probably not politic to say. But it's very simple. You take it online. Most people finish it in 25 minutes. And the thing is, and this is after my time in college, you may have taken exams that you had a time limit on a computer or something like that.
Sure, absolutely.
Okay, so it's an hour. If you finish it like most people do in 25 minutes, you have to look at the computer screen until the hour passes before you can go to the next part. So as I tell them, if you knit, if you have to read a book, if you do crossword puzzles, keep yourself occupied for the hour. When the hour elapses, they ask you some questions, they take your check, they send us the certificate. We now have prepared the schedules and statements of affairs, all the direct that we file, and we'll have sent that to the client to look at. If it's copacetic, they'll come in the next day and sign everything. And again, getting back to the other things, they're just going on trying to settle your cases. If you call them up and say, what's going on? We're working on it.
We're working on it.
And which is a great answer.
Sure.
A better answer is I don't recall, but how can you not recall? Well, you can, but so now we file the case and it gets, we upload it. There was a time when I used to hand deliver it, but no longer. I would disappear when I worked for that guy for hours. There were no cell phones, no this, no that.
No way to check in.
Going to the bankruptcy court, oh my God, I'm going to be there for 3 hours and I'd be home. But that's neither here nor there. So we filed the case. They scheduled the 341 meeting of creditors. That if we would file the case today, which is the October 10th, the meeting would probably be sometime in November. Since COVID, the meetings take place by phone. So my client comes to my office for the meeting. They never meet the trustee. Prior to the meeting, we send the trustee a lot of information and also an affidavit confirming that I confirm that they are who they say they are. And as I tell clients, the wait to be heard at the 341 meeting will be longer than the meeting itself, because unless you're the first one at 9 o'clock or 10 o'clock, whenever they start, the later into the day you are, the more backed up they get. But the meeting itself, like today, if it was 10 minutes, it was a long time. And like I said, creditors don't show up because the notice of the filing says that this is an assetless case. So don't bother. Mm-hmm. And I may have mentioned the trustee. They're all attorneys like myself. In an assetless case, they get paid $65 a case, whereas the trustee in the Bitcoin case stands to maybe retire, but we won't talk about that. I don't understand it. And this guy, they can track the Bitcoin. They know when he moves it from wallet to wallet, but he's the only one who has the ability to actually access the Bitcoin. Uh-huh. And it's like the Wild West.
It is. Yeah. It's an interesting world.
And now actually, just as the trustees at the 341 meetings are starting to ask debtors that question, do you have Bitcoin or Bitcoin wallets? Of course, there's the perfect answer. I did, but I forgot what the code is.
I forgot I don't know how to get it.
I had 10 million Bitcoin. What can I tell you? I tried.
I'm a billionaire if I could get my Bitcoin.
Well, I had a gentleman consult with me. He read about Bitcoin and he wasn't yet old enough to take money out of his 401k without penalty. So it had to go back in within a year. He took $750,000 out and bought Bitcoin. And when he had consulted with me, he had forgotten that code.
The code, yeah.
And couldn't get into his wallet. And somebody wanted $300,000, and there was no guarantee that they would be successful. And, if you've read these stories, you have a certain number of times.
Yep. You have a certain number of times and then it locks. Yeah.
I know he never came back, but, I pity the poor schmuck have to pay penalties and interest because I doubt he was going to be able to put the money back into his 401k.
No, probably not. Yeah. Well, that sounds like a big oopsie.
Hey, listen, if the roast falls on the floor, that's one thing. If the Bitcoin can't be recovered, it's something else.
That's a great point. Well, Zagazit, everybody. Thanks for joining us. Visit levineslaw.com
to
get in touch with Barry Levine. And
Zagazit.
Yes, what Barry said. Thanks.
I'll send it to her in an email.
All right, please do. I'll work on my pronunciation before next episode. Thanks everybody for joining us.
Next episode, tell them, is going to be totally in Yiddish. We're going to go the whole way.
I'll know Yiddish completely by then.
Hopefully I will too. But
thanks for joining us, everyone. Thanks, Barry.
Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.